welcome back to Finally Revealed. In this episode, I want to talk about bankruptcy, but in a little bit different way. I want to talk about what happens when someone who owes you money files bankruptcy and what you need to do as the creditor. You are called a creditor if you are the person or company that is owed money by someone, and they are called the debtor. In a bankruptcy case, the person who files bankruptcy swears under oath that they are listing all of their assets and all of their liabilities. Liabilities meaning debts. And when they do that, they need to put the name of the party, person or entity that they owe, and the address. And then what happens is when they file the bankruptcy, a matrix is formed, and that is just a mailing matrix. And so those people or companies on the mailing matrix are notified first by mail that there was a bankruptcy. So if you get mail, somebody owes you money and you get something in the mail that's from a bankruptcy court, or in the case of a very large company bankruptcy, it could be by a service that sends out the notice for the court or the debtor. You need to open that because it's going to give you the information about the case, when it was filed, and where you need to go to make your claim, if that's what you want to do. And so it's important for you to know that information because there are going to be deadlines in there that apply to you. But most importantly, you need to know that when someone files a bankruptcy who owes you money, you have to stop. So if you are in the middle of suing someone and you've got an attorney or you're doing it on your own and you are filing papers against them, you need to notify the court. They should actually notify the court, but you need to stop. So if they haven't filed anything with that court where you're pursuing them, you need to do that. Number one, because you can't do anything. There is an automatic stay from the bankruptcy court, which is a section of the federal court, and it supersedes, it goes over and above anything else that's going on, and you have to stop. You can pursue relief from the stay through that bankruptcy proceeding in a certain procedure, but until that is done, you can't do anything. So you need to notify the court where you're pursuing this person or company that you are not allowed to do anything. So in some cases, if you don't pursue your case, you'll either be set up on a dismissal docket or the court will just throw it out or set a hearing. You can't do anything until you get relief from that stay. So it's really important, if you get any notifications like that, that you open them. And if you have an attorney who's representing you in a case against someone who has now filed bankruptcy, you need to notify that attorney and send them a copy of the paperwork. And then they'll take care of everything, and they will then advise you as to what your rights are in the bankruptcy court, or they will make a referral for you to an attorney who can do that. And once a notice is filed with the court pursuing the party that a bankruptcy has been filed, that case is now suspended. So if you obtain relief, or the bankruptcy is dismissed and the stay is lifted that way, then you can go back and finish your case. If, however, the bankruptcy proceeds and you haven't made a challenge to them based on fraud or some other basis why your debt shouldn't be discharged, then in the normal course, in a if it's a consumer, a Chapter 13 case, your debt is going to be classified as secured or unsecured and taken care of through the plan in as many as up to 5 years. And you may get a percentage of the debt and you may get nothing. And then in a Chapter 7 case, if you have collateral and you have properly perfected that interest, you may get the collateral back. But in a Chapter 7, if the only way you'll get payments is if they want to keep the collateral. If you're unsecured and you're just suing them for money that they owe you, either that you gave them or because you paid something for them, most likely in a 7, once you get a notice, you should face the fact that you're probably not going to get anything back. But that just depends on how they filed the case, and you need to at least, I wouldn't walk away, but you just be prepared for that answer, okay? But once a stay is put in place, which occurs automatically in a voluntary case, absent other circumstances. And when you get that notification from the court, it means there is a stay, and it says it right on there. Then you cannot do anything else, because if you do anything, you can be penalized. I hope this was helpful. If it was, give me a like, share it with someone who might need it, leave any comments or questions below, subscribe to see the other videos, and come back and see me next time. Thanks for watching.